So, the steps a successor trustee or an executor needs to take after a person passes away. Well, the first three things I would recommend to do, and this happens outside of any court or attorney's office, is one, letting the mortuary or funeral home, whoever's handling the body, let them know what that person's social security number is. That will in turn allow the funeral home to alert Social Security of the person's passing, as well as let the county clerk know of their passing, which will allow for death certificate. Another practical piece of advice is if they were living alone at a residence, be it their home or an assisted living or a nursing home, remove any personal identifying information and any medications, or at least making sure that those are locked so that someone can't come in and try to pilfer it afterwards. As for what you do after those points, which may be a week or two, what I would say is, well, it depends on which realm you're in. For a will and everything, that's where you have an executor, where pursuant to how probate works, that person, although they may be named to be the executor, does not have any authority to collect any of the deceased's assets. They need to start the process of opening a probate estate and obtaining letters of authority in order for them to be able to act and access the deceased's accounts. Whereas with a trustee, depending on the terms of the trust, they can start acting immediately, either by signing an acceptance of trusteeship, which can be a simple piece of paper, or by acting in the affirmative, whereby they just start acting on that role and showing papers of trusteeship to certain financial institutions, and they can really start the process a lot sooner before an executor would in a will, per se. You can reach me in my office by calling us up or at nick@dellenbushryanlaw.com.